name is Dr. Zanyango Nyalwide. I am a Deputy Public Trustee. And the Office of the Public Trustee basically is an office within the Office of the Attorney General, department within the Office of the Attorney General. And it's established under an Act of Parliament, which is Capital Law, Chapter 168 of the Laws of Kenya. And the office exists to administer estates and trusts. So basically, we handle matters of deceased persons who have been referred to the public trustee for administration, which basically involves succession, ensuring that the property that the person who has died is administered and is connected to the beneficiaries of the estate.
Kwa jina naitwa Edward Mwoki Samson. Hii idara tulio ni idara ya public trustee. Mtu anaweza kupata mwananchi anaweza kupata huduma katika ofisi iliyo karibu naye. Kama kwa maeneo ya Pwani, Mombasa au Malindi ni sawa. Kama kwa maeneo Ukambani huko Machakos hivyo ni sawa. Maeneo ya Magharibi, Kisumu, Kakamega, maeneo ya Bonde la Ufa, Nakuru, Eldoret na kadhalika hivyo. Embu, tuna ofisi Meru, tuna ofisi Garissa, tuna ofisi Kisumu, tuna ofisi Kakamega, tuna ofisi Eldoret, tuna ofisi Nakuru, tuna ofisi Mombasa na pia tuna ofisi Malindi.
Under the law, there are different people can be able to refer matters to the public trustee. One, the beneficiary themselves can actually report the death of their relative to the public trustee and request the public trustee to administer the estate. Number two, the court sometimes on its own motions have the mandate, and many times they appoint the public trustee to administer estates that have been referred to court. And maybe the beneficiaries are not able to agree on who is supposed to administer the estate, because you know that especially when you deal with succession matters, they involve a lot of controversy. So when the courts find that the beneficiaries are not agreeing, they usually refer the matters to the public trustee to administer. This is to ensure that the property is safeguarded. And then number three, you can find that even the creditors, sometimes they feel that the deceased person owed them certain things, and they refer the matter to the public trustee. But in most cases, you find that the matters that we handle, most of them are actually referred to us from the Treasury. And basically, they relate to estates of public servants who have been working for the government and they have died, and there is gratuity that's payable to the beneficiaries. So those ones are usually referred to the public trustee as the initial step before administration can be done.
Jambo la kimsingi ni yeye kujifikisha tu kwa ofisi yetu, iwe ni ofisi yetu kuu ama ofisi zetu za katika maeneo ya tofauti ya Kenya. Ukishafika hapo, kuna stakabadhi au fomu huwa tunakupatia ili ujaze, ili utupe habari tunazozihitajia. Inajulikana kama PT form 1. Ukijaza hiyo fomu na ukiandamanisha na nakala za cheti cha kifo na nakala za cha kitambulisho, kama wewe ni mtu mzima ambao umejaza hiyo fomu, itatusaidia kuweza kuwasiliana na wale ambao na idara za serikali zinazohusika ili kufanya uchunguzi kujua ni wepi warithi wa marehemu. Tukishapata kujua warithi wa marehemu, tutawauliza watu ruhusu kuwa wasimamizi wa mali ya marehemu. Ikiwa wataki, basi watafuata ule mkondo wa kwenda mahakamani wao wenyewe binafsi.
The steps involved will actually differ based on the nature of the estate we are administering. But the main key steps are, number one, there has to be a reference to the public trustee. Once this matter has been referred to the public trustee for administration, the public trustee will actually now write to the deputy county commissioner. Because when you fill the report form of death, you actually list where you are coming from, where the deceased hailed from, who are the beneficiaries, and then now that gives us a basis to investigate. Because you see, like somebody can come and report the death form and probably they're leaving the name of certain beneficiary, maybe it's a polygamous marriage, so it is one family that is reporting and they don't give other names. So once we get that information, then we write to the Deputy County Commissioner in respect of the area where the deceased came from. Why do we write to the Deputy County Commissioner? Under the law, they are the ex-officio agents of the public trustee. And when we write to them, they are able now to get back to the DOs, to the area chiefs, and they get clear information to confirm that indeed this person came from that area and the children of the deceased. Once we get that information, then now we give consent to the beneficiaries, especially those who are above the age of 18. Why we do that is that under the law, the beneficiaries actually have a higher priority to the public trustee to administer the estate. So the consents they are given, they're actually saying that they're giving the public trustee the authority and the mandate to deal with the estate on their behalf. So all the beneficiaries who are above 18 years old are supposed to sign the consent. When you get that consent, then we are able now to collect the estate, which actually relates to the property that the deceased had. They could be land, they could be money in the bank, they could be shares. So once all these are collected, then we are able to know and ascertain what is the value of that estate. If it is a piece of land, we write to the land valuer, who will give us the value of the land. We write to the banks to ascertain how much money is in the account. And then once this is established, then we're able to establish the total value of the estate. Why do we talk of the value? The value is important because this will determine whether we'll go to the High Court to obtain letters of administration, or we'll deal with the estate under summary administration, because the public trustee has powers to deal with the estate summarily, especially estates that are below 3 million, we don't need to go to court. But as long as the estate is above 3 million, we have to petition for letters of administration. So once this is done, based on the kind of estate that you're dealing with, if it is under 3 million, a summary certificate is drawn, signed and sealed by the public trustee, and this concludes the administration of the estate. This summary certificate can actually then be used to access the money in the bank, used to transfer the piece of land, and then the final distribution account is done and the file is closed. When the estate is above 3 million, that it means we have to go to court. You file letters of administration, seeking for grant of letters of administration from the court. Once the court issues the grant, then you have to seek for confirmation of that grant. When the grant is confirmed, that is when the public trustee will be able to get to the bank, get the money or transfer the property. Once only this is done, then the file can be closed. So there are those two avenues, whether it is a summary administration where we deal with the office summarily, or we have to go to the court to get letters of administration based on the value of the estate.
Ikiwa mtu ametuacha pasi na kuandika wasia ama will, ile sheria ya usimamizi wa mali, sheria the law of succession ina vipengee vinavyopeana namna ya kugawanya mali ambayo ni ya marehemu ambaye aliondoka pasi kuwa na wasia. Inaorodhesha nani anafaa kupata kwanza na anafaa kuwa na urithi wa aina gani.
The Law of Succession Act provides avenue in which administration can be done, whether it is polygamous or non-polygamous estates. We find that under Section 40, the law clearly provides what happens when somebody has left a polygamous estate. You're supposed to take each house as a unit and then include the surviving spouse as an additional unit. So you see, if it is, let's say somebody had 3 wives, and the first wife had 2 children, the second wife probably had 1 child, the fourth wife had 5 children. So you see, all those children are taken together plus a unit. That's an individual unit. Then you add the surviving spouses. So each and every family gets what is entitled to that family based on the units that are there. So you'll find that probably one family, let's say if they are a total of 10, in all the families. So the first family probably will get 4 over 5 over 10 based on the number of children. So that one, the law clearly provides what's supposed to be done. So it's not for us to decide that this is how we are going to distribute. The Law of Succession Act clearly provides what is supposed to be done, so that it is actually about equity in distribution, not equality. So we won't say that it is a third. Every family should get a third, but based on the number of children and the surviving widow.
Kama hakuwa na mke au na watoto, basi tunapatia baba kwanza kama yupo, kama hayupo mama, kama mama hayupo ndugu zake na dada zake, kuendelea.
Let's assume I have died and I owed somebody money. And somebody else is going to take out letters of administration. Gazettement gives an opportunity for anybody who has a claim against that estate to lodge their claims. Or probably the person who wants to take out the letters of administration is not a beneficiary, or it's not somebody who has a right. Probably it's a family, let's say it's a polygamous family, and one person goes to obtain letters of administration, excluding the other family. So the gazettement is actually an opportunity to give anybody to object or to seek to be enjoined to administer the estate of the deceased person. The issue is to ensure that at the end of the day, because the law provides that before you distribute the estate of a deceased person, any debts any liabilities must actually be established and paid out, so that whatever you are paying out, you have actually cleared. Because you see, this person has died. Does it mean that if he owed somebody money, that person should not get their money? The money should go to the beneficiary to the exclusion of these debtors? So that is the essence of administration, that anybody can actually go and object or raise their claim, so that those claims are proved and paid out before distribution of the estate to the beneficiaries.
Tuseme kwamba huduma ambayo hatutoi mashinani moja kwa moja ni ile huduma ya malipo ya bima, kama vile ukipokea hizi pesa za malipo ya bima ya ajali ya wafanyakazi wa utumishi wa umma. Hizo huwa tunalipia hapa kwa ofisi kuu, huwa hazilipiwi mashinani. Lakini hizi huduma za usimamizi wa mali ya marehemu, ambao ni mali ya marehemu moja kwa moja, hiyo zina mwananchi atapewa huduma huko chini, hana lazima ya kuja huko. Hii mambo ya kulipa malipo ya bima ndio tunalipia hapa juu peke yake, hapa ofisi kuu.
I think what you need to understand is that the public trustee is a creature of an act of parliament, which is the Public Trustee Act. And as I stated earlier, our role is to administer estate and trusts. And unclaimed financial assets do not administer them, they receive assets that are unclaimed. So our process is to administer, to ensure that we take charge of the property that have been left with deceased person, go through the court process, get the orders that are necessary, and then connect the beneficiary to the assets. But the Unclaimed Assets Authority, they receive probably funds that have been left by, this is somebody has died and the money was in the bank and nobody knows. So anybody who will go and claim the funds from the Unclaimed Assets Authority, they have to be told to go back to court, obtain letters of administration, or come to the public trustee to administer the estate. So that is something that is key. Unclaimed Financial Asset Authority do not administer estates. They're just holding property that has not been claimed. But the public trustee, we hold property, we know the person who has died, we administer the estate and transfer it to the beneficiaries. So that is one distinctive factor. They do not administer estates. And that is a court process. The public trustee actually has the power to administer estate.
Ili kuwaridhisha Waislamu, mali ya watu ambao ni wafuasi wa dini ya Kiislamu ikija mikononi mwetu, huwa baada ya kudhibitisha warithi ni akina nani, huwa tunatafuta ushauri wa kadhi. Kadhi ndiye anatupa namna ya kugawanya hiyo mali. Kwa hiyo huwa tunafuata maagizo ya kadhi kulingana na alivyotuandikia.
So it is good for the members of the public to understand that even in administration, there are processes to be followed. This is not just limited to the office of the public trustee. Even if the individual beneficiary goes out or engages a private advocate to follow the administration, the processes that we are following are the same processes that we followed in the court, because they actually outlined in the Law of Succession Act. So I think it's just sensitization of the public to know that indeed these are the processes that have to be followed for purposes of ensuring that proper administration is done. For me, that is very key. When they don't understand, then it becomes a bit difficult. Somebody will think that probably you want something, you're not administering the estate because you are interested in something else. But it's just the processes that have to be followed. Because the moment the money gets here, you must be able to advertise in the Kenya Gazette. Why do you advertise? So that anybody who has a claim can be able to raise their claims that they have with the public trustee. Then you must be given the legal mandate to administer the estate, which is an order from the court or the certificate of administration that the public trustee has. So if they don't understand that, then somebody can actually feel that probably the process is delaying. But for me, sensitization and the public understanding the process of administration is very key.